Hello and welcome, everyone. I'm Margarita Pinton Perez, the Community Partnership Leader with the Learning Network at the Center for Research and Education on Violence Against Women and Children. On behalf of the Learning Network, welcome to our special event, The Journey to Ottawa, Understanding and Transforming Publication Ban Law. To open, we would like to start with a land acknowledgement. We acknowledge that we are learning, speaking, and hosting this virtual event on the traditional lands of the Anishinaabe, Haudenosaunee, Lenampewak, and Chinangton nations. These lands are connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. Today, this land continues to be home to many Indigenous people from across Turtle Island. We give our deep respect to the first inhabitants of this land and recognize that an acknowledgement of Indigenous land and sovereignty comes with the responsibility to understand the history and ongoing impacts of settler colonialism. These impacts continue to be felt in disproportionate and everyday ways against Indigenous communities. We also reflect on those who came to this land involuntarily, particularly those brought to these lands because of the transatlantic slave trade and slavery. As the Learning Network is focused on mobilizing knowledge to end the spectrum of gender-based violence, we also recognize that today, these nations face disproportionate forms of gender-based violence and a crisis of missing and murdered Indigenous women and girls and 2S LGBTQIA+ peoples. We recognize the responsibility for our work to be informed of the colonial imprint and harms that shapes the experiences of GBV among Indigenous peoples. We commit to furthering our work in ways that best uphold solidarity with Indigenous survivors and those supporting them. I'd like to now warmly welcome our speakers. We are thrilled to be joined today by Morrell Andrews and Carrie Low from My Voice, My Choice. It's a real honor for the Learning Network to be able to connect with and share the work of these two outstanding advocates. They will introduce themselves, so I'm going to pass it over to them to do so and start the presentation. I will then rejoin Carrie and Morrell for the Q&A period after their presentation, where I will share the questions that you, the participants, shared in the Q&A box. So please join me in welcoming Morrell and Carrie.
Hi, everyone. Good morning. Thank you so much for your welcome. My name is Morrell Andrews, and I'm joining today from the traditional, ancestral, and unceded land of the Musqueam, Squamish, and Tsleil-Waututh nations in what is known today as Vancouver. My day job sits within the federal public service, and I have a passion for policy and governance, which is in part what brought me to some of this work. I come to this conversation today as someone who has reported a historical abuse that was perpetrated by my driving school teacher in 2013 when I was 18 years old. I was living in Ontario at the time. The offense took place in 2013, but I didn't actually report until June 2020. After my driving school teacher pled guilty in April 2021, I found out that there had been a publication ban on my identity that had been placed since October 2020 when the accused first appeared in court. I was never asked if I wanted this form of protection. No Crown attorney ever gave me an opportunity to indicate that it wasn't something that I wanted. And I wasn't actually formally told that I had a restriction on my ability to publicly identify as someone who had gone through the court system and experienced abuse. Knowing immediately, though, when I had found out that there was a publication ban on my name, that I did not want to be anonymous, was the first step in my journey to Ottawa. I asked both the judge and the prosecutor in my case about how to remove the publication ban. And unfortunately, neither were able to help. The Crown attorney told me that she wasn't sure if the Crown would consent to the removal of my publication ban. And the judge indicated that she was no longer the judge that had jurisdiction over my publication ban in the case, and that she couldn't help me at all. I was confused and I felt extremely lost and had no idea where to turn for help. And after finding out that there were little resources, that there were no legal clinics that could help me, there was no information that existed online, and with a Crown that was too busy to help me, I became infuriated and also really upset. And so the only recourse I felt I had was to go to the Toronto Star and tell them about what happened to me. Once the Toronto Star published my story with me anonymous, the Crown attorneys finally got back in touch with me and agreed to put forward an application to remove my publication ban, which unfortunately the accused in my case contested. So we had to go to a hearing to sort it out. Finally, my publication ban was removed in May 2021. And after a very long, painful court process, my journey to Ottawa officially began.
Hi, everyone. My name is Carrie Low, and I'm happy to be here today. And I want to thank the Learning Network for inviting us here to speak about our journey to Ottawa. And thank you, Morrell, for co-hosting this with me. I'm excited to be here. So I want to acknowledge that I'm coming from the traditional, unceded, and ancestral territory of the Mi'kmaq people, known as Mi'kma'ki. May we recognize the deep trauma and ongoing impacts of colonization, including gender-based violence. And I also want to acknowledge the African Nova Scotia people who have faced systemic racism and gender-based violence for centuries. And may we all commit to listening, learning, and supporting efforts toward healing and justice for both communities. So usually when I introduce myself, I say that I'm a survivor of sexualized violence. I also still consider myself surviving the legal system. I'm heading into year 7 now, and my legal processes are still ongoing. I'm also the founder of Survivors for Change and Empowerment, which is a community-based program that offers legal advocacy to other victims and survivors who are facing challenges in the legal system. So a little bit about my publication ban story. It's always hard to sort of trim it up in 2.5 minutes, but I'm going to do my best. So on September 13th of 2019, I first went public with my story. I filed a judicial review after the Office of the Police Complaints Commissioner dismissed my police complaint due to the 6-month time limit here in Nova Scotia. I went public not because of what happened to me, but because of what happened after I reported to police. 16 months previous, on May 19th, 2018, I reported to the police in the emergency room of my local hospital after having just gone through a forensic exam. I reported that I had been drugged, kidnapped, and raped by multiple men. On May 5th, 2019, due to a faltered police investigation, I filed police complaints against the Halifax Sexual Assault Investigative Team who were responsible for investigating the crime I had reported. The Office of the Police Complaints Commissioner rejected my complaint as it started the clock on the 6-month time limit at the time that I reported to police what happened to me, and not even considering I didn't have concrete evidence of the police mishandling the investigation until I requested a Freedom of Information and Protection of Privacy request on my file, with the addition of asking for the HRP sexual assault policy. On February 12th, 2020, almost 2 years after the assault, the first accused was arrested in my case. And on April 8th of that same year, a Nova Scotia Supreme Court judge ruled that the Office of the Police Complaints Commissioner breached the duty of fairness owed to me and set aside the commissioner's decision, sending it back for determination after applying the doctrine of discoverability. During this time frame, I had been working collaboratively I had been collaborating with a freelance journalist working on the CBC podcast, Carrie Low Versus. Knowing trial was coming up in November of 2021, my lawyer and I met with the Crown prosecutors in July to let them know that I was working on this podcast and it would be aired in the beginning of September. I wanted to ensure that I was being transparent and accountable with my intentions. During this meeting, not once did either Crown advise me there was a publication ban on my name, nor that there would be one, as a matter of fact. Nothing about publication bans had ever been brought to my attention. Their only concern during that meeting was that if I talked about the events of that night, it could be used as another statement in court. I reassured them that the only thing that was discussed about that night was pre-recorded version from 2019 that was done before anyone had been arrested. On September 1st of 2021, I received a call from the reporter who was at the CBC station. They had just received an email and a letter from the Nova Scotia Public Prosecution Service advising them that they were aware of the podcast that they were working on with Carrie Low, and it was due to be aired, and to let them know that there was a publication ban on my name. Therefore, the podcast could not be broadcasted. I was devastated, and I was especially angry. I felt completely betrayed by the system that was there to protect me. It almost felt malicious and actually calculated. They didn't even contact me. I had to find out from the reporter. I immediately called the Crown and disclosed my anger and demanded it to be removed immediately. However, I was told that there was a process. I would have to hire my own lawyer, make an application, and have a judge decide whether the ban could be removed or not. And finally, after having done all of those steps, I finally had my publication ban removed in October of 2021. So what is a publication ban? A publication ban outlined in section 486(4) of the Canadian Criminal Code is a court order that restricts the dissemination of information which could identify a victim complainant or a minor witness in sexual offense cases. Established by the Supreme Court of Canada in 1988, publication bans in sexual offense cases aim to shield complainants from widespread publicity, preventing further trauma or harm that might arise from public exposure. It prohibits publishing, broadcasting, and transmitting of such details. And its primary goal is to safeguard the privacy of the victim complainant. This again would encourage survivors to report sexual violence without fear of exposure. And this ban is not designed to shield the identity of the accused. Publication applies to all parties involved, including judges, lawyers, court personnel, witnesses, the public, including journalists. And contrary to common misconceptions, a publication ban doesn't render the case a secret. Court proceedings and records remain accessible, but individuals are restricted from revealing the information that could identify, again, the victim complainant or minor witness. While other publication bans are discretionary, these bans become mandatory for a judge to order upon request from the prosecutor, victim, or minor witness in sexual offense cases. Publication bans remain in effect indefinitely, regardless of the trial outcome, and until lifted by a judge. Failure to comply with a publication ban order constitutes a summary conviction, punishable by a fine of up to $5,000 and/or imprisonment of up to 2 years less a day. Publication bans carry both positive and negative implications, reflecting the duality in their effects on sexual assault victims. Publication bans serve as a crucial purpose in protecting the privacy and dignity of victim complainants and minor witnesses. Again, they act as that shield for those individuals, safeguarding them from shame and negative consequences associated with public identification. And this protection is essential for preserving their privacy and dignity throughout the legal process. Publication bans aim to encourage reporting reducing the fear of retaliation. They can create a safer environment for victims to come forward and report instances of sexual violence. And this increased sense of security encourages more victims to seek justice, potentially to higher rates of reporting and prosecution. Again, upon request, judges are mandated to impose these publication bans immediately. This ensures swift action to protect the anonymity of victims. These bans, again, like I said, they remain in place until it is lifted by a judge, providing continuous protection and beyond regardless of the trial outcome and even after death. Again, by shielding survivors from public exposure, they can create safer spaces for survivors to focus on their healing and recovery journey without the added stress or judgment from the public. And some victims feel safer providing testimony and cooperating with the legal system when their identity is protected. However, victim complainants are often unaware of publication bans, like Morrell and I both just spoke about. Prosecutors typically do not seek their consent or even inform them of the ban's existence. This lack of awareness limits victims' ability to make informed choices and consent to the restrictions placed on their own identity, and nor are they aware of the consequences for breaking the order. And publication bans may give the impression that accused individuals are protected, causing additional further harm and shame, and hindering the victim's ability to openly discuss their experiences and seek support. Strict enforcement of publication bans may lift transparency and accountability in the legal system, making it challenging to raise awareness and educate the public about sexual assault cases within our judicial system. So the impacts of unwanted publication bans. So again, like I mentioned before, prosecutors typically did not seek or obtain consent from victim complainants before requesting a ban on their identity. In reality, many prosecutors automatically ask the judge for a publication ban upon the first court appearance. And this is long before the victim complainant is even involved in the process or participates in the proceedings. The law did not mandate the court or prosecutor to notify a victim complainant of a placed publication ban, leading many again to be unaware and the potential penalties for breaching. Unwanted bans can be paternalistic, and imposing restrictions without consent can restrict a victim complainant's freedom of expression, reinforce those feelings of shame, and suggest that anonymity equals protection for everybody. Lifting an unwanted publication ban was challenging, often leaving the victims and survivors to navigate the legal system alone, having to hire a lawyer, potentially at significant costs, just to assert their right to speak. Again, with the inconsistency of the legal system and how the law is applied by judges and attorneys, it's challenging and extremely harmful. For instance, some judges might seek input or standing from prosecutors or even the abusers before deciding on a publication ban, while others may not. These inconsistencies can undermine the consistent application of justice. And knowing that an abuser has a say in whether a victim or survivor can speak about the trauma they experienced can be re-traumatizing, exacerbating the emotional and physical harm that they've already suffered. And again, due to the penalties for breaching a publication ban, a victim can also be criminalized for breaching their own publication ban. And in March of 2021, a Kitchener-Waterloo sex assault victim was fined for breaching her own publication ban. The victim pled guilty, breaking a publication ban order, and was fined $2,000 in order to pay a $600 victim fine surcharge. She was not in court when the Crown asked for a publication ban at the start of the assault case, and the ban was not discussed with her. Therefore, she could not and did not consent to it. She had sent a transcript of the judge's reasons for finding her ex-husband guilty of sexually assaulting her to friends and family, as they obviously already knew their identities. Someone, not the victim, sent it to a female friend of the man. The man contacted police, and she was charged with breaking a publication ban protecting her own identity. There were numerous steps in the process where the legal system failed her. The police chose to lay a charge, the Crown chose to prosecute, and her defense attorney maybe recommended pleading guilty. At that time, this case could prove to be a catalyst for change. And I do believe she was right. Eh, Morrell?
Absolutely. So I think this story of the women in Kitchener-Waterloo is such an important one, and it's really what galvanized and started the work for me personally. But I know many of us who are involved in this advocacy. So in the spring of 2021, when I read about what happened to the woman in Kitchener-Waterloo, I was absolutely scared because I didn't want the same thing to happen to me. But learning about her case also reaffirmed what I had experienced in court, that the law as written was not well understood, that there were no supports for victims and complainants to navigate publication bans, and that many people were also likely being harmed by this antiquated law. So on May 14th, 2021, when my publication ban was removed in court, and for almost an entire year after, I began sketching out the path for legislative change. And we've distilled it into 5 steps, the path to change, and how we actually went about legislative reform. But before anyone could get to step 1, we had to go through an internal process. And I'll speak for myself here in that, you know, what was really significant was the internal battle that I had to go through that made me feel overwhelmed and fearful and insecure, and also unsure about what right I had, as someone who had gone through the court system and been harmed by it, to then come out the other end and say, you know what, this was a terrible experience and this doesn't feel right. Something needs to change. I often wondered if what I was doing was the right thing to do in setting out to change the law, and knowing how many cases are deemed unfounded and how terrible it is to go through the inhumane court process, and just like how marginalized communities have so much less access to accountability and justice through the legal system. I had to wonder, like, is this what we should be focusing on? Publication bans have hurt me and, you know, at least one other person in Kitchener-Waterloo, but is this the issue to focus on when there are so many things that are part of the legal system that are not fair and are unjust and actually harm people? You know, it was difficult also to contemplate the grueling path that we would face in legislative change when many of us had just come out of court processes and were burnt out and hurting. And, you know, I felt like a shell of myself. It was very difficult to sit down and actually commit to it. But what's really important, and I think is a cornerstone of the work that we did, was that, you know, everything we did was in pursuit of something better, but it didn't have to be perfect. We would strive to be perfect as much as possible, but ultimately the pursuit of perfection is futile. If we had sat down and contemplated what people would say if we didn't get it 100% right, exactly perfect, especially because many people involved don't have a legal education, you know, that would have stopped us doing this work. But perfection isn't real, and this journey was not perfect. And I think it's important to preface this presentation by saying that there was no perfect time to start. The law as amended today is not perfect, and that nobody who was involved in the work claims perfection. Perfect, of course, is a very noble goal, but at the end of the day, through this path to change, things actually, I think, improved. And that was done in the context of a very complex system. Parliamentarians and their staffers listened to us and many other people involved in this advocacy. The Minister of Justice and his department wrote a bill that was amended by the Senate and then the House of Commons, and progress is often imperfect. But having started with that caveat, we can start at step one, which is find your people. So when this all began, we had no coalition, no group of advocates built to actually undertake this advocacy and figure out what exactly we wanted to see changed. So I personally, in October 2021, started to send some emails to parliamentarians, and I had actually found out that at the same time, many other people were also doing the same, but we just hadn't come together yet. So before anything could start, we had to build a team that had a like-minded goal. And we were able to do this in part thanks to social media, because a few of us had become, a few of the people who were involved in the advocacy had been in touch with each other separately. So Carrie and I were connected through Twitter after I posted something about my publication ban being removed on Twitter. And we had, kind of talked briefly in 2021, but when it was clear that there was maybe an opportunity to start doing the advocacy, we got in touch again and started to form the group that is known as My Voice, My Choice. Same thing with other victims who were involved. For example, Kelly Favreau in Victoria had been in touch with many people through Reddit and Twitter. And she reached out to pretty much any person in a news story about publication bans across the country. And we started to create a network of like-minded people that grew over time. But we had to actually find them first and then solidify the group. So that's what we did. We also were really intentional in getting in contact with experts and practitioners who were willing to help and lend their time for free. So this was really important for us to find people who were experts in the law and had direct experience with removing publication bans and going to court and speaking with judges, who could advise us on the things that we were hoping to achieve, but also, give us some information that was really important to make sure that what we were going to do made sense, that the flaws could be addressed, if there were limits in the law that we knew about them. And they also just gave us some additional legitimacy, honestly, because of their time and their generosity in helping ensure that, what we were advocating for and talking about actually made sense within the context of the criminal code. We also had to identify all the decision makers who we would need to target in order to actually ensure that our recommendations eventually turned into amendments to the law. So one of the days, an exercise that was really important was sitting down and mapping out all of the folks in the political world who we would need to talk to. So I literally have a piece of paper somewhere at home where it's scratched. I created a system map that actually targeted every single person in the different political parties and the departmental structures in Ottawa who we would need to reach out to. After doing all this and identifying the team with the like-minded goals, the experts and practitioners, and the decision makers who we needed to be in touch with, a really important aspect was investing in the relationships that would get us across the line, and that we would be able to, build trust with, have open communication with, that we would be able to address conflicts or questions as they came up. And, within the core team, it was really important that we made consensus decisions as much as possible. Sometimes it wasn't possible, and that was really difficult. But I think that we approached the work in a way with, that was goal and oriented towards the final target. And we sometimes had to make decisions that, individuals didn't agree with, but it was the way that we were able to get the law amended. And I would also say that it's important to cultivate a support system outside of the people who are doing the advocacy and the work. So, you can't just focus on supporting other people. You have to support yourself when you do advocacy. And part of that was really useful when things got really hard and there was a lot of pressure on us to get things right. I personally spent many hours crying to my partner on the phone and at home. My therapist knows the story inside out. I barely saw my friends or family for a couple of years and, told them that I would eventually come back. My work managers knew what was going on in this advocacy. My doctor approved stress leave for me for my actual job. I was a mess when we did this work, but building a team that you trusted and supported, both inside and outside of the work, was so important. And I feel every day so grateful for people like Carrie, and all of the group of My Voice, My Choice, and the many people who lended their time and ears and thoughts to us, because it made getting through the work actually possible. The second step is to get organized. So a lot of the hard work we kind of front loaded by sending out hundreds of emails in a very disorganized way about our own personal stories and how the law should be changed. And that was before we really sat down as a group of advocates and said, okay, how are we actually going to do this? So when we were a little more organized, we were able to sit down and say, okay, we've been in touch with people. No one has responded to us. Maybe this is an opportunity to sit down and become a little more organized. So I have a list here of things in order that I think are critical for anyone who is seeking changes to laws and how to organize yourself. So the first thing is understanding that if you can have the best network and a group of people who are willing to help, but success is very improbable without organization. And so these are the things that worked well for us. First of all, doing your research. So we sat down and researched as much as possible about the section of the law 486.4 of the criminal code, so that we understood what it said, if there were cases online on the legal database CANLI that could tell us a bit about how the courts were viewing the issue. We tried to track the history in articles and like legislative debates and compile all the resources. So we actually had a full picture of what the past was, where we were today, and where we wanted to go. Part of this is also understanding the legislative process and how laws get made and what terminology means. It's very inaccessible to go through the Senate and the House of Commons and the committees and try to understand, how actually a bill gets written, created, amended, and then passed. So doing the research was so important. And there are some resources throughout this deck that will help you understand how exactly those processes work. The second thing is to develop recommendations. So once you've done your research and you understand kind of what you're working with, it was important for us to sit down and develop concrete recommendations so that we could identify ourselves what exactly needed to be changed within the law, and also so that we could be specific and prescriptive for decision makers to actually understand what needed to happen. So, it's important to use those recommendations as a reference in everything that you do, and also give them to everybody so that there's a unified understanding of what you're asking for. It's important to write these recommendations in a way that is concise, that's clear, and and also fairly brief, because parliamentarians, as we learned in the process, have very limited time and they want to know exactly what you are asking of them. So your recommendations are a vehicle, essentially, that government and parliamentarians can understand. The next thing is to sit down and write a briefing note. It is the language of Ottawa and Parliament and government. And in order to write a good briefing note, you need to have done your research, you need to develop your recommendations, and then also be able to summarize exactly the issue and your recommendations that you want to see changed. So the briefing notes are really great because we use them as a reference in every single meeting with any member of parliament, with any senator, even with the media, who we often liaise with. If we had a briefing note that had, kind of a similar message and, the core background information, we could just hand it to someone and say, this is everything you need to know. It's not everything, obviously, that we've done research on, but these are like the key messages that you need to know. And that was really helpful. We were able to update it constantly and submit it to committees. And that was just like the greatest thing to have, I think, personally, but I'm biased because I'm a public servant. The fourth thing is writing a critical path. So once we had all of our information, we had our briefing note, we needed to actually sit down and say, okay, what is realistic in terms of our path forward? What's every single action item that we need to achieve in order to get to our final goal, which is passing the bill and royal assent? We sat down and committed to one common critical path that kept everybody on track. And this helped us immensely. I was constantly updating the document almost on a daily basis, I think. And it helped the team know where we were going and what was coming next. All the things we needed to do to prepare for a committee, what we needed to do over the summer when Parliament was on a break so that we could kind of reorganize ourselves and respond to changes in the law as it was being amended live. So the day that I was able to finally change the last kind of status row to complete, royal assent complete, that was the day that I was like, we have freedom, we did it, it all feels actually real, because the critical path reflected that. Next is to track everything. We accounted for every single email, every single phone call, every single message that was left on an answering machine of an MP's office in Ottawa, because it allowed us to actually, keep stock of who we had contacted. We were able to be more effective with how we reached out to folks and could reference, previous conversations and any action items for follow-up that, a legislative assistant or a director of policy had committed to doing. So our tracker was so important, and I recommend that everyone, at minimum, includes a critical path and a tracking sheet to keep you organized in everything that you do. As a team, we communicated very frequently. We used WhatsApp, Slack, we had meetings. Every time we had a meeting with an official, particularly the minister's office, there was a high-level summary given to the group so that everyone was up to date and understood, what we were working with. We consulted extensively. And in hindsight, I think one thing that would have helped us in communication would have been, more formal and regular scheduled meetings. But there's also an important piece of context that, like, we were all doing this work off of the side of our desks. Like, this was no one's full-time job. We all had different commitments in life and work to go on, in the regular 9 to 5 hours of the day. So this was done on the side, but I think it would have been really helpful if we could have some of that more formal and organized meetings. And finally, number 7, remember the goal. So when you're tired, when you're stressed, when you're busy and things feel like, they're really hard, having the goal and remembering the goal kept everyone on the same page and organized. I think it drove our work forward and ensured that we were accurate and detail oriented and continued to push forward to the amendments that we wanted to see. It can be easy sometimes to let organizations slide when lots of things are going on, but I think these things on this slide were why we were very, very successful. And on the next slide, I've given a brief outline of what a briefing note actually, the structure of a briefing note, if you want to use it and adapt it in your own work. But I've also linked an example that we gave to the Justice Committee that summarized the issue of publication bans, what we wanted to see, and some of the background information. So step 3 was create momentum for us. I talked a little bit earlier about how important it was in refining our message, having key points to register and then repeating those things over and over again to parliamentarians. And I really, I can't stress enough that it's so important to have a standard message, because if you have a standard message, everyone understands, okay, Carrie and Morrell are in the room. We know what they're going to say. They've been really clear with us what they expect Parliament to do. So, that's the task and we have to do it. In the briefing note that I've linked earlier in the slide, this was kind of like one of the iterations of our messages. But it's important to note that as we went through the process, those key messages had to be amended based off of what members of Parliament were saying publicly, or what news articles came out, or when the bill was being changed in the Senate and in the committees and then in the House of Commons. So your message should be obviously ever evolving, but it's important to formalize the message, stick with it as much as possible, because parliamentarians are busy people. They have multiple competing priorities. And what helped us was making our message easy to digest, clear, so that they knew what we were asking for, and also consistently repeating it over and over and over again. The media was so great in creating momentum for us. So as a group, we knew that getting the message out was absolutely critical. And if we were in the news, then staffers in Ottawa and parliamentarians would pay attention. There's a certain legitimacy, I think, that comes along with being able to say, you were on the front page of the Globe and Mail, and different outlets are paying attention. So definitely using the media and leaning on them and reaching out to them frequently to update them on key milestones along the way was something that we did really, really well. And they kept in touch with us and were very happy to support us. I always thanked all the journalists who I spoke with, because I felt like they were part of the team. They helped us get the message out, and without them, I think we would have faced maybe additional challenges to actually breaking through the Ottawa bubble and ensuring that Parliament paid attention. And part of that helped us find the many, many champions who were absolutely vital to this work. So members of Parliament from all parties, senators from all groups, we spoke to any staffer who wanted to speak with us. We did not say no to anybody, because we understood that the issue of publication bans and essentially the right of a victim or complainant to share their own story was not a political thing. It shouldn't be politicized. It wasn't a partisan kind of winning point. It was something that we wanted all parties in Parliament to get behind. And so some of the amazing champions on the House of Commons side who we benefited from included Laurel Collins from the NDP, Randall Garrison from the NDP, Frank Caputo from the Conservative Party, Larry Brock from the Conservative Party, Karen Vecchio from the Conservative Party, Rob Moore from the Conservative Party, Réal Antoine Fortin from the Bloc Québécois, Sébastien Lemaire from the Bloc Québécois, Elizabeth May from the Green Party, former Justice Minister Lametti from the Liberal Party, and current Justice Minister Virani. So they were absolutely amazing. We kept in touch with them, and they were such great champions for us across party lines. And I think reaching out to everyone and not bringing politics into it was one of the things that helped us. In addition to those types of champions who were political, we leaned on, women's organizations, civil society, people like the Women's Legal Education and Action Fund, which is also known as LEAF, the National Association of Women and the Law, Elizabeth Fry Society, Ending Violence Association of Canada, and others were really important interlocutors for us to have, because they were large organizations that, again, could affirm and legitimize some of the things that we were saying. And they were also able to participate in the legislative process and, you know, amplify some of our points and bring their own expertise and their own networks and the respect that parliamentarians have for them into the process. So they were just like the most amazing folks. And there are more groups than this, but those are some of the ones that really stick out. And, you know, I think it's also important to capture the fact that there were many, many victims who were involved in this work, those who were part of My Voice, My Choice, but also those who had different levels of bandwidth and capacity to lend themselves to the work. So many people reached out to us on social media and said, you know, I have a similar story and, you know, I don't know anything about the law or legislative change, but I want to, you know, help in the ways that I can. And so keeping in touch with those people were also, I think, so important. We kept them consulted on everything. And, you know, they gave such incredible insights and were able to broaden the scope and how we viewed the issue, because every single person's experience across Canada was vastly different. We knew that we couldn't speak for everybody, but we wanted to be very intentional and worked really hard to, you know, reach out and hear from people. And there's so many more people that I wish we could have reached, but because of our lack of capacity and the fact that we just did this very informally meant that we couldn't reach everybody. But every single person who reached out, we brought in and involved. And I think, you know, that's something I'm really proud of us for doing. Creating a petition was really important for the work, ensuring that we actually had a formal document that could be introduced in the House of Commons that included our recommendations, you know, helped spur progress along. Laurel Collins from the NDP in Victoria sponsored our petition and was just like an amazing champion and advocate for us. We ended up getting 5,000 signatures, and the petition was introduced in the House of Commons actually on a day that we were all, or many of us were present in the House and got to witness that. And that was a really special time. So I think, like, when you're talking about creating momentum, finding champions, leave no stone unturned. Look everywhere for information and ways to reach out to people and amplify your voice, and say yes to everything, because we did. And it was very tiring and exhausting, but super, super important for us. And I think, you know, I would do no justice when we talk about all of this work, and, you know, creating the networks and creating momentum and the message without mentioning My Voice, My Choice. And so you'll see on this slide, there's 5 of us in this picture. It's not everybody in the group, but this is from a Globe and Mail article that was published, which was very cool. It was on the front page of the Globe and Mail. And My Voice, My Choice was an initiative created by victim complainants for victim complainants to demand amendments to how publication bans were used. And I've just included here some of like our 5 key messages that we used from the beginning to the end that had to slightly be amended and evolved as we went through, but those were our key messages and key asks of Parliament. Finally, we went through the legislative process. You know, we had a petition, we reached out to parliamentarians, we were organized, we were talking to the media. And then finally, we got to a point where the government said, yes, we're going to move on this issue, and you're going to have the issue of publication bans included in Bill S12. So this is a quick snapshot of what the legislative process actually looks like in case you're not familiar. So first reading happened for us and our bill in April 2022. No, is that right? 2023. No, it was very fast. April 2023, our bill was introduced in the Senate. So basically that just meant that the government tabled the bill. Parliament had noticed that this new bill was coming down from the government. It was read in the Senate, where it was just like a quick high-level debate with a few senators, and then it was sent to committee for study. So we were able to appear in committee we were able to give our insight and our suggestions to the bill that the government had produced, because we weren't involved in writing it. We didn't actually know what would be in the bill when it was tabled, but we had significant suggestions and improvements because it wasn't quite as ambitious as we wanted to see. But the government was very willing to have conversations with us and to hear about the ways that the bill should be changed. So we were able to really get into the nitty gritty and sit down in the Senate with a list of principles that we wanted senators to consider when they amended the bill to make it better. Once the committee stage was done and second reading, that whole process was over, the bill went to third reading in the Senate. It was passed with major amendments, and then it was sent over the summer to the House of Commons for their consideration. So it had to do the same process in the House of Commons. First reading when it was introduced in September 2023 in the House of Commons. Second reading happened shortly after. There was very brief debate. The bill was referred to the Justice Committee, where we again were able to appear and give our advice, our considerations, things that we wanted to still see in the bill that weren't amended by the Senate. Unfortunately, not many of those things were accepted, but we tried, we did our very best, and the bill was finally, had its third reading and then received royal assent in October 2023. And you can read more about how that process happened in the link that I have below. Bill S12 passed in October. And so now, you heard what Carrie mentioned earlier about what was required. But now with the amendments to section 486.4 of the criminal code, you have to be asked about whether you want a publication ban. You must be informed about your right to revoke the publication ban. There is now a clear codified process to how to remove or modify your ban. Your abuser cannot argue that you should remain silent forever. You cannot be prosecuted for breaching your own publication ban, but it's important to know that there are other considerations that remain in place and that you can look at in the criminal code, and that you can talk to a lawyer, a doctor, a counselor, or people in relationships of trust without fear of breaching your publication ban.
Thanks, Morrell. I just want to add a couple tidbits of advice when you are heading to Ottawa. Definitely wear sneakers and pack Band-Aids. We were running from meetings to meetings, offices to offices, buildings to buildings, sometimes without even time in between. And it rained the whole week the first time we were there in May last year. So sneakers, Band-Aids, really important. So what happens next? So just recently, updates needed to be made to the Department of Justice website. They did so May 15th of this year. While they have made the improvements, there's still room for enhancement, particularly in the wording of the resources. And it's crucial that we have access to clear and understandable information about our rights and our laws that govern us. And we will continue to be in touch with the Department of Justice for advocating for clearer language and more accessible content. And sharing detailed information about legal changes is essential for fostering transparency and accountability within our legal system. Again, too often, legal reforms are implemented without adequate public awareness or understanding. As advocates for justice, it's incumbent upon us to bridge the gap by disseminating information about legislative changes in a clear and accessible manner. Whether through community workshops, educational seminars, or online resources, we must ensure that everyone has the opportunity to stay informed and engaged in the legal reform process. And awareness about how to promote legislative reform from the outside. Many people do feel powerless. I know I did in the beginning, in the face of complex legal structures. But there are tangible steps that we can take to advocate for reform. We just heard from Morrell with a step-by-step process, which I do believe she needs to copyright. And by mobilizing grassroots movements, connecting elected representatives, and participating in public consultations, we can amplify our voices and push for the changes that we want to see. I'll note here there is a link to the National Association of Women in the Law, and they created an open access course called Feminist Law Reform 101. And this is for individuals and organizations in feminist law reform and promoting equality rights. And it's a valuable resource that taps into the expertise of feminist lawyers and others involved in federal law reform to offer a toolkit for advancing this kind of vital, important work. And again, while we've made significant progress in amending publication ban laws in sexual offense cases, there are definitely still challenges to overcome in addressing sexual violence cases effectively. Continued collaboration and advocacy and commitment are essential to creating a more equitable and supportive environment for addressing these issues. And moving forward, sorry, my past. So again, moving forward, addressing provincial issues. So let's look at the path moving forward in our ongoing efforts to support victims and survivors of sexual offenses in the context of publication ban laws. Again, like I mentioned, there are still several challenges that remain. And one of the primary challenges we face is a variation in how publication ban laws are applied across different provinces. Currently, that I've only been able to find, only British Columbia has a streamlined process for varying or revoking publication ban laws, leaving many survivors without access to crucial information and support. Other provinces are lacking updated information, which hinders victims' access to justice. So collaborating with justice departments is crucial to ensure accuracy and timely results. So ensuring legal consistency, federal and provincial justice departments need to develop clear guidelines. They need to create these guidelines for judges, legal practitioners, victim services workers on when and how to apply publication ban laws, to eliminate ambiguity and ensure a uniform application. They also need to establish mechanisms to monitor the implementation of publication ban laws and address any discrepancies or consistencies in their application. Enhancing survivor resources. So there needs to be a creation of comprehensive resources for survivors. Information materials need to be developed to distribute clear, accessible information about publication bans, including pamphlets, websites, and maybe even helplines. Support tools can be created that support survivors in understanding their rights and options, such as interactive online resources and mobile applications. Implementing comprehensive training. Effective training for those involved in the legal process is vital, and our provincial justice departments needs to do so. They need to train their legal professionals and how to implement mandatory training programs for judges, lawyers, victim services, and law enforcement on the importance and nuances of publication ban laws and supporting survivors. And we need to have continuous support for victims. Providing robust support for victim complainants is crucial, and ensure that victim complainants have access to comprehensive support services, including legal aid, counseling, and advocacy, by providing a holistic support. Empowerment programs, develop programs that empower survivors by providing them with the knowledge and resources that they need to navigate the legal system effectively. And most importantly, we need to review the law. Continuous review and improvement of publication ban laws are necessary to adapt to changing needs and contexts. Regular assessments can be conducted of publication ban laws to identify the gaps and the inconsistencies and areas for improvement. And stakeholders need to be involved. Involving a broad range of stakeholders, including survivors, legal experts, and advocacy groups in reviewing and updating the laws to ensure that they meet the needs of those who are designed to protect. Supporting victims and survivors. So now the crucial ways that we can support victims and survivors of sexual offenses as they navigate the complexities of publication ban laws. This support involves prioritizing the survivor's agency. First and foremost, we must prioritize the agency of survivors in deciding whether to vary or revoke a publication ban by respecting and supporting the survivor's decision regarding this ban. They should always feel in control and never pressured to take any particular action. We need to offer them clear options. Clearly present all available options and the potential consequences, allowing the survivor to make fully informed decisions. Empowering survivors with the right information is essential. By explaining the laws, simplifies the complexities of the publication ban, explaining their purpose, the application, and the circumstances under which they can be varied or revoked. We need to detail the process and clearly outline those steps and ensure survivors understand their rights and protections under the law, as well as the risk of lifting a ban. We also need to offer emotional support and validation. Supporting the emotional well-being of a survivor is critical, and you can do this by listening actively, providing a non-judgmental space where they can express their feelings and their concerns. Active listening shows empathy and validation, acknowledging their strength and their resilience, and affirm the courage it takes for survivors to seek information and make decisions about their own cases. Connecting victim complainants with legal resources and support organizations is essential. Guide survivors to legal professionals specializing in publication ban laws and sexual assault cases. There are legal aid services with independent legal advice programs in certain provinces. Pro bono organizations can also be invaluable. Additionally, connect survivors with organizations in your area offering counseling, advocacy, and peer support. These organizations provide additional emotional and practical support. And so importantly is to discuss safety planning. So when working with a survivor lifting a publication ban law, ensuring the safety is paramount. Identifying the risks of lifting a publication ban. Collaborate with the survivor to pinpoint potential risks associated with the disclosure of their identity and develop strategies and a plan to mitigate these risks. Address the dangers of social media, emphasizing that offensive or inappropriate comments might be posted about them online, which could result in re-traumatization and potentially lead to cyberbullying. Create a comprehensive safety plan that includes steps to enhance their security, maybe such as changing their contact information and securing their living environment, as well as using tools to, we've talked about this, WhatsApp and Signal, having conversations on protected apps, or meeting in person. And maintaining the privacy and confidentiality is extremely important to ensure all communications with survivors are confidential. Like I just mentioned, using secure methods to inform survivors about their privacy protections, limit information sharing and share information only when absolutely necessary, and most importantly, only with the survivor's explicit consent, including interactions with other professionals and support services. And this also means obtaining ongoing consent. Ensure that you have the survivor's consent each and every time before you share their information. And advocacy and awareness. So advocacy for policies that center on survivors' needs by engaging with policymakers and promote laws and policies that prioritize the needs and rights of survivors in the legal process. Work with community organizations to ensure that survivor-centered practices are implemented and upheld. Raise public awareness is vital to dismantling rape culture and challenging societal attitudes that perpetuate victim blaming and stigma. And we can make a difference by supporting and participating in educational campaigns that highlight the importance of respecting survivors and understanding the impact of publication bans. So engage in community outreach to educate the public about the realities of sexual offenses and the importance of supporting survivors. And finally, it's crucial to center survivors' voices and decisions. Acknowledging their experience, acknowledging their expertise in their own experience is vital. Empowering survivors by validating their experiences and supporting their decisions regarding their cases and personal narratives by providing platforms for survivors to share their stories if they choose to do so, ensuring they lead the conversation about their experience and their needs. Again, like I said, while significant progress has been made, there are still challenges to overcome sexual violence cases effectively. Continued collaboration, advocacy, and commitment are essential to creating a more equitable and supportive environment for victims and survivors. I personally would like to express my sincere gratitude to my fellow team at My Voice, My Choice for their tireless advocacy and dedication to this cause. Our efforts have not gone unnoticed, and our commitment to creating a more just and equitable society is truly inspiring. As we are all transitioning into new chapters of our lives, know that our work has made a profound impact on countless individuals across this country, including myself. To everyone here today, I encourage you to take action in your own province. Inspire others to support this cause by highlighting the power of collective impact and positive change. Some of us, and I know I am, we're tired and we need to rest. So it's essential for others to join in advocating for the rights of all victims and survivors within the legal system. Together, we can create a world where survivors of sexual violence receive the justice and the support that they deserve. Thank you.
Thank you so much for sharing your journey with us, Carrie and Morrell. And I echo the comments in the chat. Thank you for your work with My Voice, My Choice. It's really so inspiring to see what's possible, and it really speaks to the dedication, the discipline, like the collective and consistent advocacy efforts that you talked about, and it makes us hopeful in terms of the continuing work. Now I want to go to the many questions that were posed by participants. And just a reminder that we continue to welcome participants to share their questions in the Zoom Q&A box, and we will ask as many as we can with the remaining time. So I want to start with the first question that was posed in the chat or in the Q&A box. It says, now that the legislation has changed, can you speak to its implementation? What has been the biggest factor in those jurisdictions that are implementing well and those that aren't? Any advice for those working in public service to help ensure success in our jurisdictions?
Carrie, do you want to start with this one?
Well, I can only talk about what's happening in my province. I do know that, like I said, British Columbia does have a streamlined process. They actually have a form you can fill out. They have pamphlets, information that you can find online. But one of the biggest factors, I think, in my province is that, again, even before the law changed, judges and crown attorneys weren't really sure of how publication bans worked. And I think, you know, with our advocacy work, being in the media, talking to people for the last few years, you know, people are becoming more aware in the justice system, but the problem is they're not making the process streamlined. So there isn't a process. And I still to this day am talking with victims and survivors who reach out to me, who still aren't aware that a publication ban has been put on their name. It's not clear what the process is. I've had success stories though, I've heard where, you know, crown attorneys are doing informing, asking for choice. And when it comes time to modifying or revoking, it's quick, it's easy. But then I'm also hearing cases, specifically more in rural locations of my province, where they just don't know what to do. And some people are waiting months, 3, 6 months or longer, just to have their publication ban looked at to be removed. So I think in each individual province, again, like I can only speak for my own, the advice that I would give everyone is to start talking to the Department of Justice. Write those emails, write those letters, request that these services need to be put in place. We need to have a streamlined process. Victims and complainants need to know how this works, and it needs to be updated on their website. I mean, I went on yesterday, and again, public prosecution policy, some of them haven't been updated in 20 years, 15, 20 years. So we really need to get updated on this information, because people, it's our right to know how the process works. Morrell?
Yeah, I think I echo exactly what Carrie has mentioned. We did this work understanding that the administration of justice is the responsibility of the provinces and the territories. You can do, a lot by amending the criminal code, but how the changes get implemented depend on a case-by-case basis, depending which province or territory that you're in, which is really frustrating because it means that there's so much work ahead that still has to get done. I linked the form in British Columbia in the chat, and it would be amazing if there was just a standardized process that everybody used that was publicly accessible and easy to navigate, that would make the process easier for everyone, but it's not the case everywhere. I think because the changes in the law are still, they're not that new, but they're still relatively new, right? Like they're not even a year old. There's probably still some legwork that needs to happen within the ministries and the various Crown offices on how to standardize the procedure when someone comes to remove a publication ban. And, my hope always is that government will be quick and efficient at that sort of thing, but we know that that's just not always how things happen. So, just like Carrie said, I think if everyone in your province and territory, if you hear the words that we're saying today and, you take up the work to just send some messages or get in touch with the ministers in your area, or your elected representatives and say, hey, what are we doing on this? Then maybe it will give them pause and, start some of that important momentum that needs to happen at the provincial and territorial level. But there's no standard, unfortunately.
Thank you. And I guess this next question, speaking about like sharing information or the updates that are necessary as well, there's some questions about what would you want gender-based violence service providers, for example, to know when considering pros and cons of a publication ban and speaking with survivors?
I'll take that one. So I think what I would want organizations to know is know your information. Again, do your research, know what the law is, reach out if you don't, talk to a lawyer, talk to legal professionals who know. You need to be able to give a survivor as much as information as you can so they can make an informed choice. And again, I think also is, working with that survivor and what they want, they get to decide, but they need to have all the information. And you can't help them decide one way or the other. It's basically giving their information and helping them lead their own way. And I also think too, potentially always talking about the risks. There's always risks of lifting a publication ban, because once it's done, it's done. And I think that's also important, again, by not pressuring someone to do, sway one way or other, just by giving the information. I think that is so important. And when they do make that decision, support them. Always support them in the decision that they make, no matter what. So, Morrell, do you want to add anything?
I think that sounds really good. I'll also add that, like, in some cases, what people need is just help navigating the system. Some people just make up their mind and say, you know what, this is what I want. I don't need someone to like explain it to me or ask, about, whether or not you've considered everything. Some people have like been able to make that decision and done the research on their own. So sometimes it's just being aware of the process and saying, okay, like if you know what you want to do, and you've made up your mind, then this is where you can go. And now that the law has been amended, that port of call should be the Crown's office, because now the Crown is required to do the application on behalf of the victim or complainant. So sometimes, everyone comes at it differently, like Carrie said, and people who need a lot of support, like amazing, but some people also don't need that and have made their mind up and know concretely where they want to go.
Thank you. That's really helpful, Carrie and Morrell. We also had a question related to if the law changed for complainants under the age of 18.
So the law applies to victims of sexual offenses. So there's a list of them, and also witnesses under the age of 18. And any other publication ban that might exist in the criminal code, it depends on the case. It's important to understand that on a case-by-case basis, what publication bans might be, in play. But I think, that's a question for like what the Crown's office has done and, the court record. It's hard for us to say if there's other publication bans, but right now it's anyone who is a victim of a sexual offense who is entitled to Section 486.4 publication ban.
Thank you, Morrell. There's a question that came in that's asking, is there some legitimate recognition that publication bans protect the integrity of open case files?
That's not the purpose and the scope of this type of publication ban. There are different publication bans to serve that function. To maintain the privacy of information, for example, in a bail hearing, or to ensure the right to a fair trial of the accused. But a Section 486.4 publication ban does not serve that intention. The offender or accused has no right to protection under that publication ban. It's not for them, it's for the victim or complainant. Sometimes, if the victim is related to the accused, they, as a kind of knock-on effect, do become protected if they share the same last name, because the identification of an accused or offender might identify a victim who wishes to be anonymous under Section 486.4. But this has nothing to do with the integrity of, a trial or the right to a fair trial.
Thanks, Marilyn. I think it's really important to be able to make that distinction and clarify. I think people really appreciated the way that you were able to kind of walk us through the different steps. And actually, one of the questions that came in is, can you help guide us, like as a worker assisting victims, in how to lift a publication, a ban, where, and I know you're sharing also to be informed and find other information, but this specific question is coming from someone based in Ontario.
I'll quickly chime in. So I think when you're guiding someone who wants to vary or revoke their publication ban, is first that victim or survivor needs to reach out to the prosecution. So the prosecution handling their case to say that this, I understand there's a publication ban. I want to have it vary or revoked. Please help me do so. So that would be your first step. And then again, like I said, because not every province is running the same streamlined process, again, it's up to that province and how they're doing things. But again, like the amendments say, that a prosecutor needs to assist a victim complainant in varying or revoking their ban. So first and foremost, contact that prosecutor.
Thank you, Carrie. So I, really appreciate, when you were going through the different steps and kind of the efforts of finding your people in the community. It seems like a lot of this advocacy was online, like connecting through X that you mentioned, and it's really nice to learn of how that community formed. There's a question did you face any harassment or any pushback in terms of organizing online? And if so, how did you navigate some of that?
Honestly, it was kind of very smooth, I would say, in terms of like people's reception to the work that we were doing and the recommendations that we were putting forward. So I personally have not experienced any harassment or intimidation. I think like it's important to acknowledge as well that the folks who made up My Voice, My Choice were overwhelmingly white, cis, heterosexual women who have the privileges associated with those types of identities. So we were always welcomed in spaces and I think taken seriously. And so we really benefited from that. Carrie, I don't know if you want to add anything else or your personal experience.
Yeah, no, I think I could echo what Morrell's saying. I didn't experience anything online about that. I think as well, you know, I should be knocking on wood somewhere. I've been very public for the last 6 years about my case, and I can honestly say I have not faced any backlash from social media, from the public. I've been very lucky, I think. And also too, I just wanted to add something in previously that I forgot to mention too, when supporting someone who wants to lift, is maybe connect them with someone who already has. So if you know somebody who has already had a publication ban lift, or maybe someone who has already been public, try to connect them with that person. I think that was important for me when I was making the decision to move forward, is talking to someone else who had that experience. So I just wanted to add that tidbit in there. Thanks.
Yeah, thank you. And I'm glad to hear that it, you know, was a different type of experience, a positive experience with the organizing that was taking place online. And I think this goes back to the way that people were really like appreciating the kind of detail that you were giving in terms of the behind the scenes, right, of organizing. There's a question if you can share some of those templates that you use to get organized, and maybe some of the ones that were related to some of the research that you did.
Yeah, if anyone if anyone wants, they can reach out. I can kind of create public template. I don't have a template right now. I just have like our stuff filled in, but if it's helpful, I can create a scrubbed version of a template that people can amend as they find useful. So if you want to like send me an email and reach out, I'm happy to do that.
Okay, awesome. I'm sure people would really appreciate that. Thank you, Morrell. And next, I have another question here that is related to, it speaks to some of the experiences that you've been speaking to, and what would be some tips that you might have for survivors that are working with news media and how to approach that?
Don't do it alone. I never recommend talking to media alone. Definitely connect yourself with organization, a sexual assault center, a legal advocate, someone who's already been public. Again, you can email me anytime. I'm on social media. Connect with someone who has done so, because it's really important to know what I don't want to, I hate using the word shoulds, but some shoulds and shouldn't stays to media. There are some great resources online, and if anyone wants those, they can reach out to me. But there's some great resources. I know Luke's Place has a feminist media resource toolkit, which is fabulous. It talks about how feminist organizations can utilize the media. It talks about supporting a survivor who's choosing to talk about their story in the media. Super important, but again, don't do it alone. Have support, and not just your support, with a legal advocate or someone assisting you with the media. Again, like Morrell had mentioned, have support on the outside. Make sure you have therapy, counseling, family supports all around are so important.
I would just add to that, when you talk to the media, I found it to be really helpful. Again, like this is my public servant showing, but to write myself a quick briefing note where I had outlined like what the key messages were that I wanted to register with the media, because you can talk to a journalist for an hour, but they're only going to pull out a few snippets. So if you're really intentional with how, like, what you communicate and the words around it, the message that you want to get across is more likely to end up in the final product if you're on message and you're concise. So I would just also give that piece of advice.
Thank you. That is really helpful, and I think some of those resources that you mentioned, Carrie, are good to refer to, and I think for people to prepare for that to not feel so spontaneous, but abilities to prepare as well for those when working with the news media. I had also a question as we were going through the presentation. It was really helpful to look at like moving forward and some of the things that you are talking about in terms of what's needed. And I think I have some some questions around maybe what you imagine in some of the training that you were proposing, or the ideas of the training. And maybe if you could just share, like, are there some topics or some ideas that come to mind around that?
Morrell, on the wording.
I mean, it's so, there's so many things that could be possible. I think it would be great for judges if judges had an opportunity to be trained by people who actually know what publication bans are and how the law has been amended about how to actually implement them. There was a case in February 2024 in Ontario, actually, though, where a judge finally, after years, decades, got it right. I can link the case if people are interested, but you know, like, I think just ensuring that judges understand how to actually like evaluate a case when someone comes to ask to have their publication ban removed, and like for Crown attorneys to understand, one, how to be trauma informed in their work as like a basic thing, and two, how to properly go about removing a publication ban would make things easier, like so much better and easier. I wish like we had infinite time to sit down and be like, let us create a training for you, or help at least. But sometimes, there just aren't enough days and hours.
I wish that too. It sounds like that's what people really appreciated, the way you were able to kind of detail and all of this information that you were able to share today. Unfortunately, that's all the time that we have for today for the special event. I really want to thank you again, Carrie and Morrell, for your time, for your expertise, for sharing with us today. I want to also take an opportunity to thank our ASL interpreters, Joanne and Jennifer. I also want to thank my Learning Network colleagues, Diane Lalonde and Jasmine Tabibi, who've organized this event and were supporting behind the scenes today with the chat and with tech. And just a reminder, don't forget to complete your evaluation form to receive a certificate of participation. A link will automatically open in your browser after the event has ended. So we at the Learning Network, we hope to see you at the next special event. Thank you so much.